Thank you, Hiral. So, welcome everybody to Town Hall for July. And as promised, we have Arya and her team from PSA Legal. This town hall is about, discussing and sharing our experiences, hearing mostly from Arya and her team on, the report that has been developed. I'm sure most of you would have seen it on our socials on the Telemedicine Regulations in Asia, a comparative evaluation report of laws, policies regulating telehealth and telemedicine in Asian countries. So this report basically examines the telehealth regulations that are there in various Asian countries. It highlights the diverse approaches and best practices that are there, and it emphasizes on the need for tailored regulation based on different countries context, technology and financial means. And it basically also, it's a tool for advocating for strong telemedicine laws and ensuring effective programs. So we have Arya and her team today. I'll just, Arya has been working with Intelehealth for quite a long time now. I think it's been what, 5 years, Arya? Yeah. Great.
Yeah, I realized I have to unmute myself. Yes, I've been working with Intelehealth for close to 5 years now. The best way to uh, talk about trusted relationships is to forget the time duration that it has survived through. So, so I do not undermine the time that has lapsed, but definitely truly value the trust that has been reposed in us. Uh, and just before we start, wanted to set out a little bit of context. What we have done is that we have tried creating a slide deck so that people see other things apart from my face, Rishi's face, Shantika's face on this presentation. And what we have done in the slide deck is to try and give a quick overview of what is captured in the 51 odd page report that we prepared with Intelehealth. But before we dive into this, I want to thank Intelehealth for coming up with the idea and enabling this comparative study. Not many organizations, and I haven't had this is one of those unique client opportunities that you get in your life that you remember forever, for the simple fact that this really uh, brings in a collective desire to come up with something that has never been done, and therefore the challenges were unique and quite some time was expended in it, roughly about 18 months, if not less, when we started on this with one country and then moved on to doing it for all the Asian countries. So quite an achievement for PSA, for all the people who worked on it. And my colleagues Rishi and Shantika uh, have religiously been looking for jurisdictional laws, trying to understand. We have tried to reach out to foreign law firms within our network to get actually reliable versions of the law. Because one of the bigger problems in trying to understand what telemedicine looks like across Asian countries is not just the fact that there are countries who have an informal structure or countries who have no laws or who have just started on a pilot, but also the fact that a lot of these laws or guidelines or pilots are reported or talked about in local languages, which necessarily need not be reliable unless and until you have certified sort of a translation. So we have done our best to actually get most authentic, relevant, and up-to-date source of information while preparing this report. The Intelehealth team has supported us massively in actually giving insights on on-ground realities, helping us structure this, giving valuable insights on what is going to make it more reader friendly, what is going to make it an advocacy document, and of course funding the entire study, without which this would not have happened. So thank you Intelehealth for this opportunity. Now we can move onto the slides, not expending a lot of time, straight off to the content slide.
Yeah.
Where
Alia, just before we dive into, I just want to introduce you to the group. What a
that's not needed.
wonderful. No, I think a lot of us do not get a chance to interact with you. So a quick bio, Arya. She's a partner at PSA, and I think the firm is headquartered in New Delhi. She graduated in 2011 and has various international and domestic clients, a very diverse business portfolio. She works with businesses in life sciences, IT, technology, media, automobile, heavy industry manufacturing, and social impact sector. Um, she's also a she's also a member of Inter-Pacific Bar Association, co-chair of IVIN Committee of ITech Laws, and she basically as a part of her pro bono services, she advises social impact organization like ours, and has a keen interest in Tech for Good organization. And she was also finalist for Asian Legal Businesswoman Lawyer Award 2023 in the pro bono category, and also recognized as a rising star of 2022 by Asia Legal Business. So we have a very, very talented team who has, worked on this. As Arya mentioned, it's a very love of labor, a very long, intense research that has been put by Arya and her team. And again, we thank you for your support and your collaboration on this.
Thank you. I think I should shorten my bio further. One line should suffice that I am happy to help. Now, will we start on the main contents? Because I'm also mindful that we have this 60 minutes, and I really want to let the attendees ask some questions. Okay. So we've structured the deck very simply to first give an introduction to the key concepts, and then explain what are the differences in those key concepts. We would also walk you through our research methodology, and then take deep dive, not deep dive, give you an overview actually of what the laws are in different Asian countries and what our key findings have been. So there are two key concepts that often are used interchangeably. One is telemedicine and the other is telehealth. Now, if I have to take a step back, what we understand is that the definition could be a little vague. Drawing the distinction or drawing a line of distinction necessarily need not be an easy assignment or an easy task. It is very easy for organizations to move from the ambit of telehealth to telemedicine and vice versa. Simply suffice it to say, telehealth is the superset and telemedicine is a subset of telehealth. As both the terms do make a reference to tele, of course, we are talking about technology being the enabler here, or the means through which, in one case, medicine or the practice of medicine is being undertaken, and the other being health is a wider ambit, which would include the practice of medicine as well as other aspects of health care service delivery, for example, awareness, healthcare advocacy, health information services, converting documentation and maintaining a health data stack. So all of that is telehealth. So what we have done in the report is that we actually started our research in understanding how countries or jurisdictions are looking at telemedicine and telehealth. And we realize that many countries do follow the definition that is provided by the World Health Organization. So telemedicine, to suffice, is the delivery of medicine or healthcare services, healthcare services. And the key requirement for telemedicine is the key need for telemedicine, or the advantage is that you are bridging distance gap. You do not have to be physically present. You can use technology to deliver healthcare or medicine healthcare rather services for diagnosis, for identification, for treatment, for the entire patient care life cycle. On the contrary, telehealth would include telemedicine and all other aspects. So today, if InsurTech decides to an insurance company or an insurance aggregator decides to collect health data, while they might consider it to be part of the insurance sector, but there it is somewhere also going to fit into telehealth in the category of health information services, enabling the health information to be collected from the hospitals and being provided to the insurers. So telehealth is a wider ambit. Now, uh, what research methodology we identified? We did primarily research on published data, legal sources, number one. Wherever we were able to identify the statutes or the legislations, the regulations or the guidelines, we followed that. We also married it with the nature of jurisdiction. So there are two kinds of jurisdiction. One is a common law jurisdiction, the other one is a civil law jurisdiction. In common law jurisdiction, the interpretation is heavily dependent on facts, while in civil law jurisdiction, it is preferred to interpret a particular statute or a guideline as it is stated. So literal interpretation is more amenable to a civil jurisdiction. Now, India is a common law jurisdiction. So given the fact that we are qualified to practice laws in India, we were more comfortable with identifying and evaluating common law jurisdictions because we understand how the judicial system works. Fortunately, most countries in the Asian region are common law jurisdictions because of shared colonization history, where common law finds its genesis. Coming to civil law jurisdictions, there are few, but then also, given that it has to be literally interpreted, I do not see a lot of bearings on how we have interpreted and presented the law. Some countries we were not very lucky with identifying the exact documents, in which case we relied on whatever information was available on trusted websites such as regulators' website or reputed news articles, peer-reviewed research papers, and wherever we relied on, wherever we had any sort of concerns, we tried getting official translated copies or English translated copies for most of the jurisdictions, barring the 9 countries where we were unable to find any help from our network of lawyer colleagues. One of the important hurdles, and the reason why we are talking about the research methodology is also because it made us realize that the flow of information, which is key for awareness around telemedicine practices, is quite is at a very low level in the Asian countries, and therefore it becomes quite important that while some countries may have telemedicine laws or regulations, some may be looking forward to exploring telemedicine and starting pilots. The degree of awareness due to lack of information is at a low, which ultimately we believe will have a cascading effect on how many takers are there for telemedicine as an alternative to conventional delivery of medicine and healthcare services. With that, I would now request Rishi and Shantika to take up what the key findings have been. Rishi, Shantika, are you guys speaking? Because if you are, then we can't hear you, or at least I can't hear you.
Yes, we were. Yeah, I was on mute and we were just figuring out the slides together. First of all, thank you so much, Arya, for highlighting the key concepts and the general overview for everyone.
Shantika, I think you skipped out on one slide, which was the countries which have the law. I think that is very important because we can do a good number tally out of 51. How many countries do have?
Rishi, do you want to take this up?
Yeah. So out of the 51 countries that we reviewed across Asia, we found that only 20 countries had a telemedicine law, policy, or a guideline in place. Now, the interesting point is that out of these 20 countries, 15 had a binding telemedicine law, whereas for the remaining 5 countries, Hong Kong, Indonesia, Japan, Malaysia, and Philippines, they either had a non-binding guideline or the law was in effect during the pandemic only. Now, another observation that we came across was that the that the utilization of telemedicine as an alternative to physical healthcare delivery was very limited before the pandemic. Only 4 countries, Singapore, China, Vietnam, and Hong Kong, allowed its citizens to use telemedicine as in place of in-person care. Now, when pandemic struck, all the governments, because of the pandemic, we were all put in lockdown, and this disrupted the healthcare delivery. And as a result, governments moved quickly, and we had a lot of countries putting in place the telemedicine guidelines and laws. As a result, some countries put the telemedicine law in place only as a stopgap measure, so that citizens could get healthcare services during the pandemic, while others, such as India, came out with an exhaustive guidelines which can be utilized not just during the pandemic, but can also be built upon for the future. Now, coming to the key observations, I now give the platform to Sayantika.
Thank you so much, Rishi. So, hi everyone. First of all, in this slide, we are going to present some of the key observations that we came across while preparing our report. These 6 parameters that you see listed on your screen, which are registration, tools, consent, privacy, medicines, and penalties. These constitute some of the key themes across every telemedicine law in every country. That is to say that in every country that has a telemedicine law, these elements were present. Maybe the constituents could be different, the requirements and compliances could be different in every country, but these are present in every telemedicine law. Hence, we thought that presenting these to you would be very important. And what we're going to do is we are going to explain each one of these parameters by taking examples of a few countries. So let's first of all start with registration. So under registration, there are 2 aspects. One is registration itself, and the other is training. So every country requires that a person providing telemedicine services in the country must, first of all, have the minimum medical qualifications that are required by that country. And secondly, must be recognized or registered or licensed, whatever the terminology may be, with the medical council or the health ministry or the regulatory authorities of that country. That's the first requirement. Now, in addition, some countries, but not all, just some countries also have a training requirement for registered healthcare practitioners to provide telemedicine services. Now, here we'll take the example of 4 countries: Bangladesh, China, India, and Indonesia. First of all, Bangladesh. So Bangladesh requires its persons who provide telemedicine services to have an MBBS or a BDS degree and to be registered with the Bangladesh Medical and Dental Council. Now, under the Bangladesh telemedicine guidelines, this council is also required to hold mandatory online trainings for all registered medical doctors who aim to provide telemedicine services. So we can say that Bangladesh has both criteria, registration as well as training. Once a doctor fulfills both of these criteria, he or she or they can provide telemedicine services. Now, coming to China. In China, telemedicine services can be provided either by a registered or licensed doctor and by a licensed medical institution. So China requires both of those things. The doctor providing the telemedicine services has to be registered or licensed, and the medical institution also has to have a license under the Chinese laws. So it has licensing requirements for both parties. And for training, the Chinese telemedicine law states that it is actually the duty of the medical institution to train its doctors to provide telemedicine services. It is not the responsibility or the duty of the Chinese government at all. The complete onus to provide training is on the Chinese medical institutions. Now, coming to India, as we all know, in India, doctors have to be registered with the Indian Medical Council. And this is also one of the basic requirements for telemedicine services. So the Indian telemedicine guidelines, which were released in 2020, they require the Board of Governors of the Indian Medical Council to provide mandatory online 3-year training for doctors who wish to provide telemedicine services. Now, in the interim period, while these training courses or programs are being formulated. The guidelines state that doctors can provide telemedicine services provided that they comply with the requirements under the guidelines. So that's for India. Now, Indonesia is somewhere very similar to Bangladesh, I would say, because Indonesia requires registered doctors and dentists to provide telemedicine services. And secondly, these doctors and dentists have to be trained. The training can be provided by medical institutions or professional organizations, or sometimes even by the government. So that's left open-ended. So that is on registration and training. Now we come to the second parameter, which is audiovisual communication tools. So every law that we have come across generally just permits all forms of audiovisual communication tools to be used. However, laws of some countries are silent on what form of tools can be used. Now, the different kinds of tools that can be used include WhatsApp, Skype, email, or sometimes even phone calls or SMSs can be used. A few countries, in addition to specifying the tools, also specify the tech standards. Now, here we'll take the examples of 4 countries again. So we have China, India, Indonesia, and Saudi Arabia. So first of all, China. China does not have any specifications regarding the audiovisual communication tools that can be used. However, China has very stringent mandates regarding the tech standards. So every medical institution must have at least 2 sets of audiovisual communication systems within their facility. This is also for doctors. It's not just for medical institutions, also for doctors. Every doctor and medical institution must have 2 sets of servers, must have uninterrupted and high-speed internet facility, must have uninterrupted power supply. And wherever possible, the law also mandates doctors and institutions to have a private virtual network to facilitate efficient delivery of the telemedicine services. So that's China for you. Now in India, India does not specify what kind of tool. Yes?
Sorry, I just wanted to say that it just not means that there is a seamless provision of healthcare services, but it also means that there is security. A VPN will perhaps, although there are means to bypass VPNs, will bring in more authenticity of the system that is being used for providing telemedicine.
Absolutely. Thank you so much, Arya, for that.
So, Arya and team, can we intervene with questions? Because keeping it at the end, we might lose the context. Is that okay?
Yes, absolutely.
Thank you. Go ahead, Sayantika.
Okay, thank you. Thank you so much, Ramesh. Okay, so moving forward with India here. India allows all forms of audiovisual communication tools with just one mandate here. It basically states that while deciding the communication tool that is to be used, the doctor or the hospital must actually decide the tool on the basis of the severity of the situation, the stage of consultation, the urgency of medical care. For example, you cannot use telemedicine services to provide medical care to a person who has been in an accident because he would require emergency services. So that's for India. Now coming to Indonesia, Indonesian law also states that all forms of audiovisual tools may be used. Additionally, the Indonesian law also states that healthcare facilities may use their own telemedicine platform to provide the services, or they may use the platform provided by the government or other electronic communication service providers. So that is there. Now coming to Saudi Arabia. Now Saudi Arabia allows teleconsultations to be held through video only with a combination of audio and chat. However, the guidelines state that audio in itself, like audio solely, cannot be used to provide telemedicine services unless no other means or no other tools are available for the doctor and the patient to communicate with each other. So that's something for Saudi Arabia. Now coming to the third parameter.
I think it is very relevant to also highlight here, given that we have today a particular state in our own country where internet connectivity has been suspended for months now, from 5th of March. And very recently, the government of that particular state, and I'm not taking the name of the state because I don't want to rile up anyone, but the conditions of easing out internet connectivity that have come up require some very strict technology requirements for even a home a subscriber who is sitting in the confines of their own homes, they need to sign up undertakings to say that I'll be using a static IP, I will be doing MAC, I will be liable for any secondary usage or any sort of breach that has happened by a secondary user for my subscribers. So really, like a country like in Asian countries, in the context of Asian countries, I think there is a little bit of context that needs to be built in when we talk about how technology is leveraged. And specifically in a sector like healthcare, we need to understand that the cultural mindset is that the easiest way to deal with certain situations would be to stop the proliferation of information. Now, information fastly flows through internet. So naturally corollary to that would be to put restrictions on the ability to use internet. Now imagine a situation where there were stricter requirements to say that you definitely need to have audio, visual, both connectivity related issues. I don't think a telecom service provider would be in a position to provide visual without an ISP enabler there. So clearly an audio circumstance actually, to my mind, helps in achieving the true potential of telemedicine. And here I am reminded of this important development that happened under the HIPAA laws in US, which have a very, very high standard with respect to what sort of technology can be deployed. They came up with a specific notification at the start of the pandemic saying that, okay, we are diluting our technology threshold requirements to now permit even consultations with unencrypted means, such as Skype or over a telephone call as well. So that's just a context to say that I think sometimes the flexibility makes telemedicine quite useful, and specifically in the context of making it reachable to the larger mass who really do not have means to avail the best healthcare or even the primary healthcare facilities.
Say, Arya, I think just around the point you brought up, right, in terms of something not being HIPAA compliant. So as a part of your study, I mean, firstly, I would say thank you for taking up this detailed study, and I'm sure at the face of it, it's a very meticulous, thorough job, which always is the case whenever something comes out of Arya and team. So, so that's a kudos on that. But the large question I have is, when you're looking at laws, are you looking at laws as in laws per se, or you're looking at laws along with regulations like HIPAA, FDA, and things like that? The reason I'm asking is, for example, some of the countries do allow WhatsApp to be used for teleconsultations, right? But they also insist that some countries insist that any telemedicine service should be HIPAA compliant, because there's a lot of patient data, sensitive patient identifiable data that gets exchanged. So in such situations, but then if you notice, WhatsApp is not HIPAA compliant, right? So have you kind of thought through this, where law and regulations kind of need to go hand in hand?
Ramesh, yes and no. The answer is yes and no, for the simple reason that while we all are very well versed with HIPAA, and I think HIPAA is also quite seminal in terms of how that law has evolved, the time when it came into picture, when perhaps rest of the globe was pretty much unaware of what a healthcare law should look like. The yes and no reason is because we have confided, we definitely do a benchmarking, which is not captured, because I don't think that benchmarking necessarily the report with HIPAA would be a fair evaluation of the way the law currently stands. Okay, what you're reflecting is a standard that is globally accepted and therefore insisted upon. Okay, but in our study, what we have focused on is all the telemedicine statutes or even non-binding guidelines wherever there are. Number one.
Sure. So your focus has been more on the core law, the mandates, statutory law per se, than the regulations, right? Okay.
No. Where there are delegated regulations under those particular laws, those have been taken into account. Where there are tools related laws, that is infosec related laws, such as privacy laws or EHR laws, electronic health record laws, or for that matter any specific law which is catered to health data, or how electronical health data should be processed, those have been taken into account. So before we actually go, we decided on a list of questions, okay, where if not providing a deep dive, the report is going to nudge you in the right direction to know where that particular law is stemming from.
Okay.
That is why I said the answer is a yes and no.
So the no part is a smaller no, right? Okay.
Yeah, but
So the no is, got it. So the no is for the very specific details of where both the regulation and statutory law will hold. Probably there you've not gone to the depth, but by and large you have covered the ground. Right?
Yes, by and large we have done covered it. We have also tried to capture brief summary of those so that there is at least some know-how or knowledge sharing that has happened, because we were very mindful that we don't want this report to run into pages, because if today I start writing only the India chapter only on telemedicine laws, I think we would cover 50 pages easily.
No, agree. I mean, because we want this to be, it's just the beginning, right? It's not like we have started and ended it today. So fair enough. If we are having any specific areas of interest, we can always ask you to dive deeper just in that area, right?
Absolutely.
Because see, that's what will be a practical scenario. When a partner comes to us asking for a solution, we may have a very specific requirement using WhatsApp in a country which requires HIPAA compliant. How do we handle it, right? So then we'll come to you. Okay.
Correct. Perfect.
Super. Thank you.
Thank you. Shantika, you want to continue?
Okay. Yes. So just continuing with consent here quickly, and then I would like Rishi to jump in. So consent is mandatory across every jurisdiction that we have come across. The type of consent could be different. Some jurisdictions do require an explicit informed consent of the patient, while in other jurisdictions, the consent could be implied by the patient accepting to use the telemedicine services. Now here, let's look at United Arab Emirates for a second. So United Arab Emirates requires informed patient consent to be expressed in either paper form or electronic form. The patient also has to be expressly provided the right to refuse the telemedicine services or withdraw from the services at any point that he feels like. Additionally, the patient has to be, before the commencement of the telemedicine services, the patient has to be informed of the whole background of the medical circumstances that necessitate the telemedicine services. Then he has to be apprised of the risks and the benefits of the telemedicine services also. And then he is supposed to provide his consent. So secondly, if you look at Thailand does not explicitly specify that consent is required. However, it does state that the doctor or the medical institution must provide information to the patient that, see, we are going to be providing the services through telemedicine, and this is the course of the medical treatment that we are going to take. These are the risks and the benefits of the system, and that's it. So it does not specifically require consent, but I think at the end of it, the patient would be required to actually give consent, even though that is not specifically stated under the law. Now here, it's also...
Just to add here, so Shantika, I think we need to tell everyone here that it is not going to be an isolated instance, that you just take a look at the telemedicine guideline or the statute that is in question, but also be mindful of respective data processing, data protection laws. Because in the context of Thailand has a fairly detailed personal data protection law, which requires or augments the necessity for consent. Because at the end of the day, even a health data qualifies as a set of sensitive personal data. And therefore, it would be important for telemedicine providers in Thailand to not just look at the telemedicine guidelines, but also take into account what is the requirement for consent or other basis of processing under the Thailand Personal Data Protection Act. Now, consent is one ground, right? Now, if it is a case of an epidemic or a pandemic that has hit, there is a larger public interest present, okay? In that case, consent can be diluted where you are trying to necessarily do contact tracing. Consent is not something that is superseding the need for contact tracing, right? That is a case of processing of health data even without consent, because there's a larger public objective that is being tried to met out, which is to contain the epidemic or the pandemic. So while we structure or speak on privacy, there are various aspects of patient's privacy. One of them is obviously making sure that the patient concerned is aware that what health data is being collected and how it is going to be collected. So telemedicine laws talk about consent from two points of view. One is obviously health data, and the other one is to inform them about what are the parameters or the limitations or the benefits of telemedicine laws. But I think it is also important to augment those telemedicine norms around consent along with what is there under the state-specific data protection laws. I think there's a question in the chat box on what is the specific consent requirement in India, written or verbal. Rishi, Shantika, would you like to take that up?
Yeah.
Hmm.
Okay, India actually has both in a way. So if a patient is requesting telemedicine services from a doctor, it is implied that the patient has already provided his consent. And in that case, the doctor is not required to seek any form of consent from the patient. However, if the doctor is offering telemedicine services to the patient, then explicit written consent of the patient is going to be required. Nitin, does that answer your question?
And also, Nitin, interestingly, health data in India is considered as sensitive personal data under the Information Technology Reasonable Security Practice rules, which clearly in Rule 5 say that before processing of any set of sensitive personal data, it is imperative to obtain obtain written consent by giving a notice which provides at least a couple of agenda items. Now, why Shantika answered the way she did is because there is a specific law and there is a generic law. In India, specific law prevails over generic law. But if you want to hit the both compliance points, it is best to actually do a written consent. And in our experience of working with various healthcare organizations that have started telemedicine projects and working with various telemedicine platform providers, we have not seen a singular case where some or the other form of recorded written consent is not obtained. Either that consent is made part of terms of use or sign up on the platform itself, that is made part of the patient care form, because you need to understand that it is coming also from the ethics guidelines, the medical council guidelines, that you need to take patient consent before any kind of treatment. So in a way, we are inclined more to say that consent is important and absolutely imperative. Obviously, there could be deviating situations, as Shantika mentioned, that implied consent would be inferred by merely participating in the telemedicine consult, despite there being no consent having been obtained. But there are other situations as well. For example, in case of a pandemic, there is actually no need for really consent. A doctor could be advising a pandemic patient pretty much without consent, and that still can be substantiated because there is larger public utility.
Sure. So Arya, speaking about, since we are delving into India, right? So how much of Disha is applicable? See, because Disha is
not
something which is, that's strange, because Disha is
not a law yet. Disha was a draft.
Not a law yet?
No,
Okay.
it was a draft and it stayed a draft, which is...
It never got implemented?
No, it never.
That's surprising.
Yes. Disha never made it to the dawn. It was hugely debated and discussed, and people think it is there, but it has not been implemented.
It seems to be like $1 million question whether it is there or not. See, because officially it has been introduced in 2018 and implemented in 19 or 20. But you're saying, is it? No, I mean, again, is it more of enforcement of the law, or you're saying
I'm saying
enforcement has not happened?
The notification of the law.
Notification itself has
There's no official gazette where this has been notified as a law.
Okay. So it's not an enforcement problem.
No, it's not an enforcement. Ramesh, could you please separately or maybe in the chat drop in your basis of believing that it is enforced?
I'll do that. Yeah.
Yeah, that would help us, because as far as we know that there has been no official gazette. In fact, Disha was superseded by something that the government wanted to do more ambitious in terms of doing more EHR related matrix, and there was a guideline that was there for electronic health records, but it is a guideline and not binding. Then subsequently after Disha, the government moved up to the whole concept of creating a digital health stack for every citizen of this country, which we'll perhaps talk best in another town hall, because I see potential of large amount of data theft and identity theft happening through those sort of health stack mechanisms. I'm not denying the benefits of it, but the risks currently, in the absence of a dedicated privacy law, seem to be very large.
Sure. I think I will take this offline with you, because this can be a longer chat. I'll talk to you.
Yeah, sure.
Okay. So just quickly finishing up with consent here. So I have two more countries to go through, basically Philippines and Kazakhstan. So Philippines also has a Data Privacy Act enacted in 2012, under which health data is a sensitive personal data and consent is required. And separately, under the telemedicine law of Philippines, also consent is required. And that also requires informed consent. So you will have to inform the patient about the risks and the benefits, the medical course that you will be taking, all of that. Now, the last country that I wanted to state here is Kazakhstan. Kazakhstan requires consent as applicable to every country. However, it does not state whether the consent has to be explicit or implicit. However, Kazakhstan has some exceptions. So basically, persons with severe mental disorders or persons who have some diseases that could pose a serious social risk, or persons who have severe mental disorders and have committed some heinous crimes, consent from those patients is not required at all in Kazakhstan. So I just identified it because it's quite a special case, and we have not seen this in any other laws except from this particular country. So now over to Rishi to discuss the next three parameters here.
Thank you, Arya. Thank you, Sayantika, for taking the audience to the first 3 points. Now coming to the point regarding privacy. Now, a confidential relationship between the doctor and his patient is necessary for ensuring that proper medical care is available to the patient. Now, if the patient is does not trust his doctor, or is hesitant that the doctor will maintain confidentiality, then it will hamper the entire process. Because if the doctor does not get the entire health information, then he will not be able to provide the appropriate medical care. Now, this aspect, or rather, I would say this obligation to maintain confidentiality and maintain the privacy of the health information has been provided across all telemedicine laws in Asia. There is also, as Arya highlighted, that privacy also involves protection and safeguarding a patient's health data. So countries such as Singapore, Thailand, China, and India, although to less extent, we cannot say that India has a separate data protection law. We have IT rules, but under all these 4 countries, health data is recognized as sensitive personal data, requiring a high level amount of care and protection as compared to other categories of data. Further, when there is telemedicine, teleconsultation happening over, say, let's say WhatsApp or a video call or an email, then it also involves exchange of test results, health records, prescriptions. Now, these are also electronic records, and data protection laws also help here in establishing the standards of protection of such health data and health record. Further, if I were to take the example of telemedicine laws of India and China, in both of these two telemedicine laws, if there is violation of the standard of care or the standard of privacy to be maintained for the health data, these two laws provide for penalties against the erring doctors, which may include suspension of or revocation of their license, as well as fines. Now, this requirement of maintaining confidentiality is not only limited to the telemedicine laws, but each and every country provides a code of ethics, a code of conduct for its doctors. In India, we have the Indian Medical Council, and there is a detailed chapter regarding safeguarding or maintaining the confidentiality of data of the patients. And this aspect we have seen is being covered across all other nations as well. Now, when it comes to prescription of medicines, the general perception or the general observation has been that most countries have allowed doctors to prescribe medicines over teleconsultations. However, in countries such as India and China, before a doctor can prescribe medicines, it has to do two things. First, it has to obtain adequate information about the patient, and then should have the view that he has obtained that the prescription of medicines is in the best interest of the patient. Now, there are also limitations to the kinds of medicines that countries have allowed doctors to prescribe over teleconsultation. It's not that you can prescribe any and all medicines over teleconsultations. However, majorly there are three kinds of medicines that can be prescribed. One is over-the-counter medicines. For example, your paracetamol, ibuprofen, antibiotics. The second category is what you call an add-on medicine. Now, for example, if there is any patient who is suffering from a heart disease or suffering from high blood pressure, and the doctor has given that patient, has already put that person under medication, but the medication is not enough and there needs to be an additional medication that needs to be prescribed. So telemedicine law of India as well as Bangladesh allow doctors to prescribe this add-on to the patient over teleconsultation. And thirdly, the telemedicine laws of India and Bangladesh also allow patients to get a refill of their medications that were prescribed when they had physically consulted the doctor. However, this is the three categories of medicines that can be prescribed over telemedicine. However, there is a general prohibition over drugs which have a high potential of being abused, drugs like narcotic drugs and anti-cancer drugs and psychopathic substances. These type of medications cannot be prescribed over telemedicine, over teleconsultation in each of the 20 countries that have a telemedicine law. I see there are questions regarding prescription of medications. So yeah, Resham, what?
Hi, yeah. Rishi, am I audible?
Yes, you are.
Hi, thanks. So a question regarding the prescribed medicines. You've said that in the 20 countries that you've looked at, psychotropic drugs are something which is prohibited from being prescribed in a telemedicine consultation. From a personal experience, my father has mobility issues and he cannot go to the doctor for his consultations, and he's a mental health survivor. So we usually do consultations either over a WhatsApp video call or a dedicated platform that the medical practitioner provides. And now, a lot of times these drugs that are prescribed, they are mood stabilizers, which could be categorized as psychotropic drugs as well. So are you implying that a mental health professional cannot prescribe these drugs in a telemedicine situation? Or like, how does it work for people, especially with, mobility issues, who are amenable to these kinds of consultations only? So that's what I want to understand.
So Resham, the telemedicine law of India is actually silent on like this particular aspect, or like especially on patients, on like high sensitive patients. The general observation with India is that there are certain kinds of medication that you can provide. And say, for example, that your father may have obtained like a general prescription physically first. Then if you are going for a refill, then in that scenario, refill for chronic illnesses or for serious illnesses, that can also be provided over teleconsultation. So say example, let's take an example of diabetes. Now, for that you need for like if you want to get a medicine for diabetes, you first have to approach the doctor physically. Once that your like the medicines are over, like once you have utilized all the medicines, then in case of a refill, you can approach the doctor over teleconsultation, and then he is allowed to prescribe or he is allowed to refill your earlier medication. Does that answer your question?
I do have some follow-ups, but I think I'll take it offline. Thank you.
Yeah, but just to add the add-on piece and the filling in or top of a medicine, please understand that safer to say that over-the-counter or list O is clearly something that you can follow through telemedicine. The prohibition that the Indian laws bring in is with respect to prescribing certain kinds of drugs. And you have to understand the essence of the law when they're only allowing list A or list B of medicines as ones which is a follow-up case. There is an add-on or a fill-in request. So if today 20 mg has been prescribed and there's need for another 5 mg of the same medication, you have already consulted the same physician. You will go to the same physician physically and get a 5 mg prescription added, because that medicine cannot be dispensed at a chemist store without that 5 mg being added onto the prescription. Or you can actually avail the telemedicine route where the same doctor is giving you the additional 5 mg. The same is a filling in request. I do not think as of date, today, any doctor, even for filling in or add-on, can be a separate doctor than the one who you have been physically visiting. If any doctor actually does it, it's kind of very, very risky for the concerned doctor, because they haven't done their independent diagnosis. They aren't aware of the vitals. They aren't aware about the cross medications, the other various complications, which is why it is important that if you are following up for anything which is a list or other than a list of medication, including psychotropic and narcotic substances or habit-forming drugs or drugs which have the potential of abuse, if it is the same doctor, I think the telemedicine laws will be interpreted in a manner to allow it. But if it is a new doctor, I don't think telemedicine laws in India allow it.
Fair enough. That's helpful. Thank you.
So this is regarding the kinds of medicines that can be prescribed. Now moving on to the procedure as to how the medicines are prescribed in countries that have provided for the procedure. Now, the first step is for the doctor to send a signed prescription. Now this prescription can be signed, like he can send a scanned copy of the prescription, or he can digitally sign the prescription. This prescription can be sent either directly to the patient or it can be given directly to the pharmacist. Now, countries such as Indonesia and China, or for that matter, even Philippines, have provided for an extra layer of verification wherein the pharmacist has also got to verify from the doctor himself that he has provided this prescription to the patient. Additionally, in Indonesia, you can approach directly to the pharmacist for like over-the-counter drugs, and the pharmacist can, without the need for a doctor, prescribe medicines to the patient. Indonesian laws also go to the extent of allowing even health supplements as well as medical devices to be prescribed over teleconsultation. Now, moving on towards the penalties. Now, so all of the telemedicine laws do have a provision regarding violations of not only the provisions, but doctors indulging in any sort of negligence or a gross misconduct. Now, gross misconduct can be number one, like initiating teleconsultation without getting the consent of the patient. It can also be prescribing medicines which are not necessary for the patient, and as well at the same time, doctors can be penalized for compromising patients' privacy. Now, the range of penalties that we have seen across all the telemedicine laws is that there are disciplinary proceedings issued against the doctor, which may lead to revocation or suspension of the license. But some countries have gone beyond that. And like, for example, Chinese telemedicine laws, as well as Singapore telemedicine laws, also provide for monetary fines. Some countries have went even beyond that, with UAE, Thailand, prescribing, as well as Philippines, prescribing for imprisonment against the erring doctors, depending upon the severity of the offense. And that imprisonment ranges from 3 years to 5 years. Sayantika, now I'll give the platform to you.
Sure, Rishi, can you move the slides? Okay, so this is basically a comparative table that we have prepared for the 15 countries that for which we could obtain the copy of the telemedicine laws. We will not be deep diving into each of these countries one by one, but this is something for you to see. The parameters that we have listed here are basically the laws that these countries have, whether the laws are binding or not, whether training is required or not, what kind of information communication tools are required, what are the services that can be offered through telemedicine consultations, whether patient consent is required, what guidelines are there in relation to privacy, what kind of medicines can be prescribed and what are the limitations here, and lastly, what are the penalties. So the first slide has it for, Rishi, can you just go back? So this slide has all the parameters for Bangladesh, China, and Hong Kong. Moving to the next slide, this lists out all of these requirements under the laws of India, Indonesia, and Kazakhstan. We'll stay for a bit so everybody can see. Okay, so this is the third slide, which lists out the parameters for Kingdom of Saudi Arabia, Malaysia, and Nepal. And yeah, this is for Philippines, Singapore, and Taiwan. All of these are covered in a lot of detail in the report. And this is the last slide, which covers Thailand, UAE, and Vietnam. Okay. Just a second. Yeah.
I just want to be mindful of the time a little bit here. There are a lot of
yes,
questions in the
yes.
well.
We are just going to quickly cover these last few slides. So these are the 31 countries in our report that do not have a telemedicine law in place. You can see that most of these countries are concentrated in the Western Asian and the Middle Eastern regions. And for these countries, we have relied upon secondary resources such as newspaper articles, blogs, etc. So just these are the key findings in the report for countries that do not have a telemedicine law in place. So first of all, we notice that most of these countries actually have listed implementation of telemedicine services as an objective in their national health strategies and action plans. So Afghanistan, in its 2016 to 2020 national health strategy, had stated that they would be implementing telemedicine services. However, after the Taliban invasion, we do not have any updates on what happened. Same is the case for countries like Cambodia and Kyrgyzstan. Kyrgyzstan, in its national health strategy, has also stated that they want to have a legislative framework in place for telemedicine laws. Another very important finding that we have here is all of these countries, though they do not have a law, they have some form of telemedicine system in place, which is operated by UN agencies, NGOs, private parties, and sometimes these parties collaborate with the local governments to actually implement the telemedicine systems. For example, if you look at Tajikistan, in Tajikistan, the government collaborated with the United Nations to actually facilitate telemedicine services to expecting mothers and young mothers for to provide them family planning services and reproductive health services. And similar initiatives have been taken up by every country that does not have a law, which is also a key finding here, that even though these countries do not have a law, it does not mean that they do not place any significance on telemedicine services. After COVID-19, I think every country has realized the importance of having some form of telemedicine infrastructure in place. And that is why all of these countries, I feel, is gradually moving towards having some form of telemedicine legislative framework in place. And now I would let Rishi quickly conclude our presentation, and then we can open the floor to questions.
Thank you, Santika. Before I go into the conclusions, I just wanted to respond to Priyanka. Priyanka, when it comes to like stating that the medicines have been prescribed via telemedicines, the telemedicine guidelines of India in its annexures have provided for a sample prescription format. And under that, there is a footnote which clearly says that this prescription is prescribed via telemedicine. So I hope that answers your question.
Yes, thank you.
Now moving on to the conclusion. So basically we have 4 concluding points that we want to make with our report. While less than half of the countries have provided for a telemedicine law, but the recognition of telemedicine is as an alternative to traditional healthcare delivery is spread across all 51 nations. As Sayantika highlighted, that even though there are 31 countries that do not have a telemedicine law, but the fact that they're accepting NGOs, they're accepting efforts being made by international organizations, as well as the fact that they've included telemedicine as one of their objectives in their national health guidelines, clearly shows the acceptability of telemedicine. Telemedicine regulations across Asia are work in progress. Now, we have examples of Singapore, India, and China coming out with vast and exhaustive telemedicine guideline explaining or rather trying to explain each and every aspect of telemedicine. But however, there are also guidelines issued by, say, Malaysia, by Hong Kong, or even for that matter, Vietnam, which is only a short 1.5 or 2-pager document, just using telemedicine as a stopgap arrangement. However, linked with this point is the fact that telemedicine standards also depend upon a country's healthcare infrastructure, the level of technological advancement that country has. So, for example, say a country with a low income group country such as Bhutan, Cambodia, or for that matter, war-torn countries such as Syria, Iraq, and Afghanistan, they may not have the financial resources, or they may not have yet developed that healthcare infrastructure or the technological infrastructure which is necessary to provide teleconsultation to the citizens of that country. And related to that, therefore, although we have telemedicine, vast telemedicine guidelines of few countries, there is still a lot of gaps present in all of these laws. For example, in Singapore, although it says that you can prescribe medicines, however, it does not list out, it does not tell what kind of medicines that a doctor may prescribe over teleconsultation, or what are the other limitations. So there's a need for an acceptable or a uniform standards regarding telemedicine, and there is a need for governments, or for that matter regulatory bodies, to come up with best practices when it comes to regulating telemedicine, because telemedicine is just not related to health laws, but as you have seen throughout this entire presentation, it also includes a lot of data privacy, data privacy laws, and consent also plays an important role when it comes to telemedicine. So these are the best practices that regulators and the health ministries of various countries to develop, and as we technologically advance, especially in India, these practices could go in a long way. Are there any more questions for us?
I think Shalini has one.
Shalini, it would be dependent on the health practitioner's location. I mean, both the places from where the patient calls as well as the health practitioner's location both have inherent jurisdiction. Okay. So if the patient goes and files a case in wherever they are, then it is equally admissible. So if you use a organizational telemedicine platform, there are various such as Radical, so on and so forth. There are various software companies that do provide. The terms of use categorically state where the dispute would be. Okay, they identify one of those inherent jurisdictions as the only jurisdiction. So then there's a contract that is put in place. This is where exactly the consent and the privacy policy and the terms of use of a particular platform are deeply significant. But if you say that you do not make use of any organizational platform, then it is important to understand that both places will have inherent jurisdiction. One was the place where delivery of service happened and the other where it was received. Now, the cause of action, therefore, would lie in both jurisdictions. So if a patient goes ahead and files a case in their respective jurisdiction, that would be equally admissible, which is more likely the case because obviously the doctor is not going to go ahead and file a case, right?
Great. Thank you, Arya, Rishi, and Sayantika today for your time and such an elaborate and deep discussion. Some questions, we can see that the team has had a lot of interest, and I hope we can expand this study later on to African Americas and the other countries also as we expand our. And thanks once again. And any, yeah,
Thanks, Arya and team, for the fabulous job. I think you have put a lot of effort in putting this together. Thank you so much.
Thank you, Arya and Rishi. It's been such a pleasure collaborating on this project with you.
Thank you, Neha, for spearheading this. And there are a couple of questions. There are a couple of changes which I think we will need to do, specifically in light of the notification that Dr. Venkat has provided. I don't know if that can be done at this point in time, but it looks like there is a change in the notification for what medicines can be prescribed. Please, Neha, I think we'll connect offline on that.
Yeah, absolutely.
Okay.
great. Thank you, everybody, and see you next month.
Bye-bye.
Thank you. Thank you.
Bye. Thanks, everyone.
Thank you.
Thank you.
Thank you.
Thank you, guys. Thank